We are often asked about whether the custodial parent can move a child out of state without the other parent's permission. In Minnesota, the parent with custody who wishes to move must first obtain permission of the other parent or get the court's permission. In 2006, the law changed to say that a parent cannot relocate out of state with a minor child unless that parent has done one of two things. Gotten either the consent of the other parent, if that parent has been given parenting time by order or decree, or gotten a court order allowing the relocation. As a result, it is the responsibility of the parent seeking to relocate out of state to file a motion with the court and get an order allowing that parent to relocate before doing so. Failure to follow proper procedure creates a serious risk. The parent who does not want the child to move may seek an ex parte order changing custody immediately, pending a hearing on the relocation issue. Under Minnesota law, whether or not a parent can move out of state is based on what is in the best interest of the child. The factors the court must consider in determining the child's best interests include, but are not limited to, the nature, quality, extent of involvement, and duration of the child's relationship with the person proposing to relocate and with the non-relocating person, siblings, and other significant persons in the child's life. Who has been the child's primary caregiver, the age, developmental stage, needs of the child, and the likely impact the relocation will have on the child's physical, educational, and emotional development, taking into consideration any special needs that that child may have, the feasibility of preserving the relationship between the non-relocating person and the child through suitable parenting time arrangements, considering the logistics and financial circumstances of the parties, the child's preference, taking into consideration the age and the maturity of the child, and whether there's an established pattern of conduct of the person seeking relocation to either promote or thwart the relationship of the child and the non-relocating person, whether the relocation of the child will enhance the general quality of life for both the custodial parent seeking the relocation and the child, including but not limited to financial or emotional benefit or an educational opportunity, the reasons of each person for seeking or opposing the relocation, and the effect on the safety and welfare of the child or of the parent requesting to move the child's residence of domestic abuse. The burden of proof is on the parent requesting to move the residence of the child to another state, except that if the court finds that the person requesting permission to move has been a victim of domestic abuse by the other parent, the burden of proof is upon the parent opposing the move. When making their decision whether or not to allow the move, the court will look at the reasons the parent wants to move, such as employment or family connections. In particular, if you would like to relocate, be prepared to show whether the move would result in a better quality of life for your children, the extent to which your ex currently exercises his or her right to spend time with the children, that you are willing to allow for longer, less frequent visits if your request to move out of state is approved, and that you will actively support such changes in the visitation schedule, that you are prepared to absorb the cost of the increased cost of transportation, and that your move is not an attempt to restrict the other parent's access to the children. The court will consider the impact this move out of state will have on your children. It is entirely possible that the benefits of increased pay or closer proximity to extended family members do not outweigh the benefits your children enjoy right now as a result of consistent, ongoing, in-person relationship with the other parents. Ultimately, the court will make its decision based on what is in the best interest of the child. There are remedies available if your child has been moved out of state without your permission or a court order, but the remedy involves filing an emergency order with the court, which is difficult to do without an attorney. If you have questions about your situation, call the attorneys at Heim, Roll & Lammers today.